All right. Well, welcome back to Chapter 4, Legal and Regulatory Issues Concerning the Paramedic. The objectives we hope to accomplish in this lecture include distinguishing legal from ethical responsibilities. As a paramedic, there are some things that certainly legally you're required to do. An ethical responsibility is based more on your own morals and hold no legal ground. We'll describe the basic structure of the legal system in the United States. We'll distinguish between administrative, civil, criminal law as it pertains to the paramedic. We'll identify, explain the importance of laws relevant to the paramedic as well. We'll define some terms to include abandonment, advance directives, assault and battery, breach of duty, causation, confidentiality, and we'll look at the different consents that are out there as well: express consent, implied consent, informed consent, and involuntary consent. We'll define the term damages, defamation. We'll look at DNR orders. We'll talk about our duty to act, look at and define emancipated minors, false imprisonment, immunity, invasion of privacy, and liability. We'll also define libel. We'll look at the Medical Practice Act and define that as well. Define what a minor is, define what negligence is, scope of practice, slander, standard of care. We'll look at tort that is intentional or unintentional. And we'll distinguish between scope of practice and standard of care. We'll discuss the concept of medical direction, including offline and online as it relates to the standard of care. And we'll distinguish between licensure from certification as applied to the paramedic, which we've previously covered in the Roles and Responsibility chapter. We'll explain the concept of liability as it applies to the practice of paramedicine, including physicians providing medical direction, paramedics supervising other care providers when they're doing their ride and clinical. We'll list specific problems and conditions that paramedics are required to report and identify where to report. We'll describe the 4 elements needed to prove negligence, and given a scenario in which a patient is injured while a paramedic provides care, we'll determine whether the 4 components of negligence exist. Given a scenario, we'll identify patient care behaviors protecting the paramedic from the claim of negligence. We'll discuss some legal concepts of immunity, including the Good Samaritan statutes, governmental immunity as it applies to the paramedic. We'll distinguish between assault and battery and how to avoid both. We'll describe the differences between express consent, informed consent, implied, and involuntary. Given a scenario where a paramedic presents with a conscious patient in need of care, we'll describe the process that's required to obtain their consent. We'll identify steps taken if care is refused, and then, given refusal of treatment, demonstrate the appropriate patient management that needs to occur as well. We'll describe what constitutes abandonment, and we'll identify the legal issues involved in a decision to reduce the level of care provided during transport. That'd be like turning the patient over to somebody who's less trained than you are. Explain the importance and the necessity of patient confidentiality, the standards for maintaining patient confidentiality that apply to the paramedic. We'll describe conditions under which the use of force, including restraint, is acceptable. We'll identify the legal issues involved in the decision not to transport a patient, and we'll look at how hospitals selected to receive patients are based on need, the hospital capability, and what your role is in selecting which hospital this patient should go to. We'll explain the purpose of an advance directive as it relates to patient care, and then how to care for a patient that has an advance directive, and we'll discuss the responsibilities regarding resuscitation efforts for potential organ donation. We'll describe actions taken to preserve evidence at the crime scene. We'll describe the importance of providing accurate documentation in substantiating the incident, and describe the required characteristics of pre-hospital care report and how it is a legal document. And then, giving a scenario, prepare a hospital pre-hospital care report, including a appropriately detailed narrative. Now, here's just some legal terminology that we need to define and get out of the way, and certainly one of the first ones is jurisprudence. And jurisprudence is just the theory and philosophy of law, or the study of law. And legal duties defined by law rules, code, regulations, statutes. Paramedics have certain legal duties that are defined not only by state statutes and state regulation rules, but also national regulations and rules. Some of the ethical responsibilities of a paramedic that may not necessarily be legal, but there's an ethical need to be responsible for these, is to treat patients with dignity and respect regardless of their condition, obliged to care for the physical and emotional needs of patients, maintaining and mastering your clinical skills, attending continuing education and refresher training to keep your knowledge up as well as your skill sets, and then being that lifelong learner, critically reviewing, continuously seeking care improvement for the patients that you care for. Report honestly, because certainly if it is determined that you altered a medical record or you weren't honest in reporting the patient's condition or how many times it took you to start an IV or do an intubation, that certainly can lead to potential legal action as well. Respect the privacy and confidentiality of patients. Work cooperatively and with respect for other emergency professionals, and respecting the wishes and desires of those patients who are competent enough to make those decisions. Now, the legal system includes, local law enforcement, state and federal regulations. Local includes perhaps ordinance within your cities, rules within your department, protocols developed locally within your service. The state is responsible for certifying and licensing paramedics as well as identifying their scope of practice. And from a federal standpoint, paramedicine deals with ambulance reimbursement. Not unless we're actively involved in the billing process, are we actively involved with reimbursement. But it is the Medicare, Medicaid, they determine, as well as insurance companies, on what reimbursement amounts will be for ambulance services. HIPAA, is certainly protecting a patient's confidential medical information. And then EMTALA has to do with anti-dumping legislation, where it's not legal for a hospital or an ambulance service that's based out of a hospital to take the patient to an alternate place without first making sure that they have some sort of emergency medical screening to determine that an emergency medical condition doesn't exist. And this is trumped at some times by things like our local trauma system and the Iowa rule concerning where patients are transported based on the severity of their injury. There are administrative, civil, and criminal laws that are out there. Certainly administrative law is the law that's on the books. Iowa Code, those sort of things are administrative laws. Civil laws involve a wrongdoing to an individual, not necessarily breaking an administrative law, but civil law has to do with harm to an individual. Criminal law, of course, is when you actually break a law and are found guilty of a criminal offense. You can always use the notorious case of O.J. Simpson, who in a criminal court was found not guilty of murdering those two people he was accused of murdering, but in a civil court he was found guilty. There were no criminal actions against him, but there were some heavy civil penalties and fines that he was required to pay. Now, your paramedic scope of practice certainly is part of the legal system involving paramedicine, and it defines a set of skills and interventions and other things that you're authorized to perform. And within the last several years, the vast majority of states across the United States have adopted the national scope of practice as a floor or a base. saying that as a minimum, all states paramedics should be able to function at this particular level with these skill sets and provide these interventions. And then individual states have made slight changes to those as it relates to the unique conditions of providing EMS within that state. Scope of practice is separate from standard of care. Now, standard of care is the conduct expected of a reasonably prudent paramedic under similar circumstances. So a good example of standard of care is that if you respond to take care of a person in a motor vehicle collision, the standard of care would be that you provide a seat collar, longboard, those sort of things, because that's pretty much within the industry what has been established is what we should do for people involved in motor vehicle collisions. That's a standard of care. Medical direction, that's your physician oversight. As a paramedic in the state of Iowa, you're not licensed you're not licensed to practice paramedicine on your own. It has to be under the auspice of a medical director or physician. And as we had mentioned, I believe earlier when we talked about medical direction, that you can have concurrent medical direction, which is standing orders, a set of protocols that prior to going on a call, the type of care that you can provide is dictated. And then retrospective medical direction would be run reviews and audits that occur after the call. Licensure is a recognition of a minimal competency, and certification is evidence of that competency. And in Iowa, we are certified by the state of Iowa, but it's interesting that in Iowa code, we are licensed. So certification and licensure means a very similar thing here in Iowa. The Medical Practice Acts, they were designed to regulate the practice of medicine by physicians. And within the Medical Practice Acts, physician designees can be appointed to provide medical direction. So when you're calling into the hospital and you talk to that emergency room nurse or the nurse practitioner or PA, while they're not physicians, they certainly can be dictated as, or they can be identified as physician designees and provide you medical direction. Motor vehicle laws as it relates to paramedicine, because I'm sure that you realize that, because you're in an ambulance and you're driving with lights and sirens doesn't give you doesn't allow you, not necessarily give you, but doesn't allow you to drive recklessly or without due regard for the safety of the public. So should you be in a motor vehicle collision while responding to a call, even if you're running lights and sirens, you certainly can be liable for any sort of damages that occur, especially if you were running a red light and you didn't slow down and you didn't drive with due regard for the safety of the public. As a paramedic, you are a mandatory reporter, and as a result of being a mandatory reporter, particularly involving dependent adult and child abuse, you're required to have 2 hours of education on dependent adult and child abuse every 5 years. And while on the clock and on duty, you are a mandatory reporter. But when you're not on a clock and you're not on duty, and let's say you witness somebody physically abusing a child at Walmart, and you're not on duty, at that point you become what's called a permissive reporter. It's not required by law that you report, but ethically it would be the right thing to do. We're also required to report animal bites. We're certainly required to report violent crimes, to include gunshot wounds, rape, domestic violence, and certain traumatic injuries, boat accidents, those sort of things. Liability and malpractice. As a paramedic, Typically, if you're working for or volunteering for a service, that service carries liability insurance. When you're caring for patients, you are liable for the care that you provide. You have demonstrated a particular competency upon becoming certified. And when caring for patients, it's expected that you at least perform to that level, that standard of care. And when you don't, that's where malpractice occurs. In the event that, as an example, you had somebody who slipped and fell and had serious neck pain and some numbness and tingling in their extremities, and you made them get up and walk and go lay down on a cot, and they became a quadriplegic, that certainly isn't within a standard of care at this point and would be considered malpractice or negligence, and you would be liable for those actions. Now, there are certain things that have to occur in order for negligence to be proven. One is you have to have a duty to act, and that's usually pretty easy. If you're on a squad and you carry a pager and that pager goes off, or if you're on a schedule and you're scheduled to work that shift and the pager goes off, you have a duty to act. You have a legal duty to act. Now, breach of duty is when you violate an established standard of care. And that's another easy one to prove as well, because there are established standards of care that we look to as we do provide care for our patients. We look at the standard of care for trauma and PHTLS. We look at the standard of care in providing resuscitation in ACLS and PALS. And if you violate that standard of care, that's considered a breach of duty. Damages, that's sort of easy to prove as well. Certainly if the patient didn't have a pre-existing problem and after you cared for them, they now have a problem, they can show damages. The tough one to prove when it comes to negligence is causation, and that's being able to prove that because of your breach of duty, that's why the patient suffered the damages. If they can make that connection and make it stick, then you can be certainly charged with negligence. Now, when it comes to negligence or it comes to litigation, we have to consider the statute of limitations. And in most states, the statute of limitations is at least 2 years. In other words, that if somebody's going to file a claim against you, claiming that you were negligent, they have 2 years to put their case together and file that claim. Unintentional tort is bad outcome from unreasonable care. And unreasonable care is defined by your peers. Certainly if you're taken to task or taken to court and accused of negligence, you will be judged by 12 of your peers. And they're going to listen to what it is that you did and determine whether or not, one, you were following an established standard of care. And if you weren't, the big question certainly is, why weren't you? And then, because of your actions, did the patient suffer damage? Contributory negligence is a situation where the injured party also has to have some responsibility for their injury. And this occurs certainly like in situations where a motorcycle rider doesn't wear a helmet and then they suffer a head injury, and they try to say that you managed the head injury inappropriately and therefore the head injury was worse than what it should have been. Well, that's going to be a tough one to prove, but they certainly could go after it, and the court would find that, part of the reason that this person has a head injury is that they weren't wearing a helmet, and they should, they should own some of that responsibility. Defense and immunity laws, Now, immunity is protection from legal liability, and mostly when we talk about immunity laws or defense and immunity laws within states, we're talking about the Good Samaritan laws. All 50 states have Good Samaritan laws, and Good Samaritan laws essentially say that, if you're doing this in good faith, and you're not being compensated, it's not your full-time job, it's not something you're being paid highly to do, you can't be held liable for a bad outcome unless, of course, the care that you provided is grossly negligent. Good Samaritan laws don't protect bad Samaritans. Certainly if you injure a patient and you intend to injure a patient, and they can prove that, then as a bad Samaritan, you would not be protected by the Good Samaritan law. Malpractice insurance is something that as a paramedic you should consider owning and purchasing yourself. And I don't sell that because I have stock in malpractice insurance. But while we know that perhaps our employer carries some of the minimal malpractice insurance liabilities for us, we also know that there have been situations where, should you be called into court for negligence, certainly your employer's insurance will protect you, and if you are found negligent, the insurance will have to pay out. But there's nothing that prevents the employer then from going back on you and suing you for the money that they had to pay out, particularly if the actions that you did were grossly negligent. Intentional torts, those are wrongs where the defendant meant to cause harm. Those are situations like assault, and that's when you threat bodily harm to a patient, or battery, that's where you touch a patient without consent, or false imprisonment, again, not getting consent from the patient and taking them to the hospital against their will. Invasion of privacy is an intentional tort, and that occurs when you share a patient's personal information. Defamation of character, again, is an intentional tort and includes slander, which is what is said. Slander is said, so it's a verbal defamation of character. And then libel is written. As an example, certainly if you said that you went to the mayor's house and you were telling everybody in town that the mayor was inebriated when you picked him up, and the mayor finds that out, or any patient finds that out, they certainly can bring legal action against you for slander. And then if you write in their medical record, which is a legal document, that the person was drunk, without knowing what their legal BA is, that's just not something that you can do. You can write in your run report that the person smelled of alcohol, that their speech was slurred, their pupils were dilated, they admitted to drinking this amount of alcohol, but you can't say things like the patient was drunk. There are some special liability issues as well. We cannot discriminate the type of patients that we respond to, and we saw this a bit certainly when the condition AIDS was first diagnosed in patients, and if a patient had AIDS, EMS providers refusing to transfer these patients or care for these patients because of misinformation they had about how this disease is spread. Also things like civil rights. Again, we cannot discriminate against a patient based on their creed, their color, their religious beliefs. And then derivative liability. We want to look at something called respondent superior. And in respondent superior, the master is liable for the acts of the servant. And this derivative liability refers directly to your medical director. And many states have pushed for legislation so that medical directors, particularly those medical directors who are medical directors for volunteer ambulance services and they're not receiving any compensation for it, that they have some sort of Good Samaritan coverage and that they cannot be held liable for the actions of their servants. And many states have written that into their Good Samaritan law. I know that Iowa did that quite a few years ago, addressed this issue of derivative liability. Now, when we talk about consents and refusal of care, there are different types of consents. There's informed consent, and with informed consent, it's what it means. You inform the patient, certainly of their condition and what might happen in the event that they refuse care. And if they're alert, awake, and oriented, and you believe they're capable of making that decision, you would certainly have to abide by it, but at least they were informed. Now, express consent occurs when a person calls 911 and you arrive. Well, the assumption is that the consent has already been expressed by the nature of them calling 911. But do understand, particularly like in cases of motor vehicle collisions, oftentimes the patient doesn't call. Somebody who witnesses the accident calls, and when you show up, don't assume that you already have consent to lay hands or touch the patient, because they may not have been the one that called at all. Implied consent is what we see in patients who are unconscious. In a patient who is unconscious, it is implied that they would give you consent for their condition, particularly their life-threatening condition, if they were awake or capable of making that. And then involuntary consent, this occurs when the patient doesn't want the consent, but because of court order or because of something where they're required to have treatment, then that's considered involuntary consent. It's important that when we're dealing with minors that we recognize that minors cannot give us consent in most situations to care for them, and that it's important that if they don't have a serious life threat, that we look for ways to contact their caregiver so that we can get consent and that at least two people hear that before providing care. Now, there are situations for every rule, and certainly the rule of minors doesn't apply to an emancipated minor. And an emancipated minor is a minor who does not live at home any longer, somebody who might be 16 or 17 who moved out of the home, has a job, is paying their own way, and isn't relying on their caregiver for food or money, those sort of things. So an emancipated minor has the ability to offer their own consent. And then pregnancy is something that we have to consider as well. If you have a 16-year-old female who is pregnant, then she can give consent for her care and doesn't require the consent of a guardian. Refusal of care occurs often in EMS, mainly because initially the insult looked bad, or the crash looked bad, or the medical condition was bad, but by the time EMS gets there, or with some initial treatment, the patient comes around and says, I don't really need your services. There's no reason for me to go to the hospital. And at that point, you've got to make certain that the patient is competent enough to make that decision. And there's a variety of ways that people do that. I know we're big with documenting the fact that they knew who they were, where they were, a general idea of time, and that they knew what had happened before we deem them to be competent. We also may, if they give us consent, obtain their vital signs so that we can record that they were stable, that their pulse ox was normal, those sort of things. And then once it's determined that a patient is competent, we also have to make certain that the patient understands the risks associated with not receiving the care. You know, if a person's having chest pain and you get there and their vital signs are stable and they're alert, awake, and oriented and they're refusing care, it'd be pretty easy just to have them sign a sheet and head back to the barn. But, you know, that's not necessarily what we should do. We should make certain that they are informed that should they be having a heart attack and they refuse care, there is a chance that they could go into cardiac arrest and die. And then if they continue to refuse care after you've documented they're alert, awake, and oriented, then that's just something that you have to accept. And then documentation is, you know, most services have some sort of patient refusal form where you can document all this information, get the required signatures, and then that would be your defense in the event that, you know, 15, 20 minutes later after you left and the patient dropped over dead, you know, certainly family members would want to know why you didn't transport them. So it's important that you really document that well. Now, there are situations where even if you have a competent patient who's refusing care and you truly believe that a patient is, you know, going to impose a threat to themselves or others, law enforcement does have the ability to put the patient in protective custody for 24 hours. So, you know, we have at times, it's not very often, but we have at times where you got this gut feeling that, boy, I'm just not going to leave this person here. I just do not feel comfortable with this, and discuss the situation over with, you know, law enforcement. Certainly discuss the situation over with family members. Sometimes a family member can talk them into going in and receiving an assessment in a hospital as well. Abandonment occurs when you turn your patient over to somebody who has less care than you. And abandonment is considered only when you've provided care at a certain level and then turn the patient over to somebody who can't provide that same level of care. So if all I've done for this particular patient is a patient assessment and maybe administered oxygen, and there really isn't anything more that they need, I can turn this patient over to an EMT, because an EMT can do a patient assessment and an EMT can administer oxygen. So it'd be different if I had the patient intubated and we're pushing medications and then just said, here to the EMT, you take care of them now. That would not be appropriate. That would be abandonment. Now, confidentiality and HIPAA deal certainly with protecting the patient's personal healthcare information, and we kind of use a good rule of thumb for this is need to know. You know, if a person had a need to know the information about this patient in order to care for them, then it's okay to share that with them. But if the person had no need to know this information, they just wanted to know what's going on, then obviously it wouldn't be appropriate to share it with them. HIPAA is a federal law requirement, and you certainly have noticed the privacy notices from many companies, insurance companies, hospitals, and those places where your protected healthcare information is being shared. You'll often get a privacy notice from those companies. Patient restraints. You know, particularly hobble restraints, being hogtied, can lead to premature death. We're not allowed in EMS to use, you know, excessive force. We certainly can use force that is equal to what the patient is using, but it's not likely that we should consider putting people in physical restraints. If there's a need for that, it's probably best to involve law enforcement. And we really shouldn't practice chemical restraints either. And that's, you know, you've got this patient that, you know, that's being ornery, and so you give them, you know, maybe a little larger dose of a sedative than you normally would to quiet them down, so they're not so ornery. That's just not something that we can do. As an EMS service, it's certainly important that within your service you have a restraint policy, and it is approved by your medical director, so that it does protect you during those particular situations where you may have to restrain an individual in order to prevent them from hurting themselves or hurting you. Now, in most situations, the patient has a choice of where they should be, where they can be transported, within reason. We're 90 minutes in any one direction from a large hospital. So if we pick a patient up and they say, well, I want to go to one of those larger hospitals in City X, and we're 90 minutes away and we're 3 minutes away from our local facility, then it's more appropriate and in the best interest of the patient in most situations to take them back to the local hospital. HIPAA does require that once a person is on an ambulance cot, a hospital-based ambulance, and the person is on that cot, then the person is considered to be in the hospital. And prior to being transferred anywhere, they have to have an examination to determine that an emergency medical condition does not exist. So hospital-based ambulance services are, often forced to take patients back to the local facility, even if that's not where they have their medical records. Again, where I'm at, we have within a 20-mile radius 4 hospitals. And you may pick a patient up and be further from the hospital that they go to and closer to the hospital that you work out of, and you have to legally take them back to the hospital that you work out of rather than their choice, particularly if you're a hospital-based ambulance. So the patient choice is often overlooked when it comes to HIPAA. Also, we have to consider Iowa's trauma system. We do have an established trauma system within the state that dictates, based on anatomic and physiologic criteria, where patients should be transported. And as an example, if you're within 25 minutes of a level 1 or level 2 trauma care facility and 10 minutes from your local facility, and your patient has a serious life-threatening traumatic injury, you have to bypass your own facility and take them to the level 1 or level 2 trauma care facility, because that's what would be in their best interest. That would be an established standard of care. That is the protocol within the state, and the trauma protocol is written in rule, so it is law. It's not something that we can pick and choose to do. It is a legal requirement, and because it is a legal requirement, it trumps things like EMTALA. So when you have a transport decision where a patient asks to go back to their local facility when that's not where you're to take them, you should follow your protocol and be able to explain to the patient why you did that. If you have any questions, you certainly can consult with your medical director. Now, again, as far as transport goes, EMTALA is the anti-dumping legislation, and as a hospital ambulance service, when you put that patient on your cot, you're now in that hospital, and the patient needs to go back to that hospital to determine whether or not a emergency medical condition exists before being transferred on to any other hospital. And EMTALA is a federal regulation that we have to abide by, unless, of course, there's a state protocol that says something different, and Iowa's trauma protocol does. Transporting a patient against medical advice, that is a situation where the patient refuses transport. You want to make sure that the patient is informed about their decision not to be transported to the hospital and given alternatives, whether it's to go to the hospital themselves, whether it's to call 911 again if something should happen, those sort of things. There are going to be situations where Your protocol might initially say, because of this, you need to transport the patient. And when you get there and you assess the patient, their condition isn't really serious enough to warrant an ambulance. A big one where I come from for years was, fishhook removal. Here at the lakes, if we'd have an individual who impaled a fishhook in their scalp or something like that, we might get an ambulance call to go pick them up. And when you get there, is that really a condition that requires an ambulance? And in most situations, no, it's not. And so, you certainly can encourage patients in that case to bring themselves to the hospital, but that also requires them to sign a refusal form. Probably one of the most gray issues in EMS is resuscitation. And what I'm talking about here are advanced directives and do not resuscitate orders. Now, advanced directives are instructions regarding the health care of a patient in the event that they become incapacitated. And they're not really effective unless they're in writing. They're not really effective unless the patient becomes ill. And they're not really effective unless the person slips into a vegetative, non-responsive state and their condition is terminal. Well, we can't tell that their condition is terminal in some situations. That's a physician's responsibility. So most advanced directives, don't really apply to EMS. Now, DNR, do not resuscitate orders, those are something a little different. That's when a person with a terminal disease or a person with a strong desire not to have CPR done might fill out a do not resuscitate order. And to help clarify things, the Bureau of EMS, along with input from the EMS Advisory Committee, established Chapter 142, which addresses out-of-hospital DNR. And in that chapter, it talks about a universal identifier that patients who do not want to be resuscitated can purchase from the Bureau and from the Medic Alert Company a do not resuscitate bracelet that they could wear so that if EMS responded and they were wearing a DNR bracelet, then you had legal liability coverage in the event that you followed that DNR request and did not resuscitate the patient. Now, DNR, advanced directives, those sort of things, don't mean that we don't provide comfort care. There are times where you may have a patient who is dying from cancer or some other disease, and you're called because they've got a lot of heavy secretions, they're having some trouble breathing, and they may need to be positioned, they need to be suctioned, they may need to be given some oxygen or even some positive pressure ventilation. That's considered comfort care, even if they have a DNR. DNR doesn't mean that we don't do anything when a person becomes sick. It just means that, should they arrest, we don't do CPR. Now, here's an example of a DNR request, but really a DNR request can be written on a napkin as long as it is signed by the patient and the patient's physician. Now, some other things to consider with resuscitation issues is not beginning resuscitation, advanced directive DNRs, not beginning resuscitation because even if a person has a DNR or a person has an advanced directive, they can change their mind right up until they draw their last breath. So, they certainly can say, no, I changed my mind. I want you to resuscitate me. So you would have to resuscitate them in that case, even though they have a DNR order. In EMS, we can discontinue resuscitation when a patient hasn't responded to the standards of care concerning resuscitation. And in Iowa, that's left up to the paramedic to make that decision. we can discontinue resuscitation when a patient has not responded to ACLS. So, based on a patient's condition, their presenting rhythm, the care that we provide, if a patient does not respond to that care, and we have all our bases covered, we've established an IV, we're ventilating the patient, we have them on a heart monitor, we've given rhythm-appropriate drugs, we've applied electrical therapy, and we've ruled out and fixed all the H's and T's that we can, then we can consider discontinuing the resuscitation. We can withhold resuscitation, not begin it at all when there's a legal reason to do so, your DNR, or the patient has suffered an injury that is not compatible with life, decapitation, an abdominal wound where all the abdominal contents have eviscerated and fallen out. In those particular situations, those are not reasons we would not begin resuscitation in those cases. If they've got rigor mortis, we would withhold even starting resuscitation. Certainly when you arrive on scene and the patient is unknown the last time they were seen up and moving around, and they appear to have a little rigor mortis, and they're asystole or flatline on a monitor, then that would be a reason to not even begin resuscitation. And rigor mortis sets in the short muscles first, and it takes about 30 minutes. So if you're having difficulty even doing a head tilt chin lift, you can't get that head to come back, the muscles in the neck could have rigor. And that's telling you the patient's been dead at least 30 minutes, and also that the likelihood of you successfully resuscitating them are pretty slim. And then if you do get them back, the chance of them being a vegetable are pretty high. We also can withhold resuscitation when they have dependent lividity, and that's a pooling of blood in the lower parts of the body that aren't in contact with a surface. Those parts of the body that are in contact with the surface, are going to be white or blanched, and those areas that aren't in contact, those lower areas on the body that aren't in contact with the surface, they'll be mottled and eventually turn blue and purple and those colors. Organ donation, it is not EMS's responsibility to make the decision whether or not a patient is an organ donor. What we can do and what EMS is encouraged to do through the Iowa Donor Network is that when you respond to a scene where you have withheld resuscitation or discontinued resuscitation, that you ask the family if they knew whether or not this person was an organ donor. Iowa legislation allows for you on your driver's license to put whether or not you're an organ donor, and then that has to be upheld regardless of family decision. And it's not a responsibility to debate or fight that with family. What we would do would ask them if their loved one was an organ donor, and we would contact the Iowa Donor Network and put them in contact with the family. And then decisions could be made by those two groups, the family and Iowa Donor Network, as to whether or not the patient is a candidate for either organ donation, which is not likely if you discontinue resuscitation, or tissue donation, which certainly is likely. Some scenes that you respond to are going to be crime scenes, and you need to make sure that the scene is safe. You need to take care of patients. That's a high priority over scene preservation, particularly crime scenes. But there are certain things that you can do. If there's a bullet hole, don't use that as your point of entry for your scissors. Cut around it so that we don't destroy valuable evidence. We want to note our path in and our path out, and do all we can to not contaminate the scene. preserve evidence whenever possible. And it's really important that when you first arrive, particularly to things like gunshot wounds and known crimes, that you either take a picture or a mental picture of exactly how that patient was lying, if there is a firearm involved, where the firearm was located, particularly if you have to move it. Law enforcement just cringes at the thought of us moving those, but if they're not available, then that's something you might have to do to care for your patient. Your pre-hospital care report, your medical record, your pre-hospital care report is a legal document. It does go into the patient's medical record. It's used for quality improvement within your service. All your trauma run reports go into the state, and all that information is used for quality improvement and research. It's also used for billing. And if your documentation is good, your reimbursement certainly might be higher. There are different levels of care that are provided, and based on the level of care, you are reimbursed at a higher amount. And if you if you don't document everything that you did, the coder may code it at a much lesser acuity level and get you less of a reimbursement. And the other thing, and the most important thing to remember about the patient care report, is that it is a legal document. And as a legal document, it is admissible to court through subpoena. And we'll often get requests from law enforcement, hey, give me a copy of the run report when you're done, and that's just not something we can do. They know that if they want a copy of the run report, that they certainly can subpoena it and follow the proper legal channels, which takes time and is more time consuming, but that's the that's the right way to do it, and avoid litigation on the part of the patient for breach of confidentiality. In summary, you have legal duties that you need to perform, and they are defined by statutes and rules and laws. You have ethical responsibilities that certainly things like showing empathy and respect and dignity for all patients that you care for. You're subject to operational policies within your service, protocols within your service, and then there are state and local regulations. Certainly state regulations include things like the out-of-hospital triage trauma destination decision protocol. And then EMS law comes from 3 government branches: the legislative branch, which writes the laws, the judicial branch, which hears the law when there is a civil or criminal wrongdoing, and then the executive branch, which enforces the law. Scope of practice is defined as a predefined set of skills that you are authorized to perform based on your level of certification or licensure. And standard of care is conduct that's expected of a reasonable, prudent paramedic. And again, that's what's going to be used in the event that there's some litigation. Did you follow the standard of care? And 12 of your peers, 12 people with your similar education and background, will be asked to examine your actions, and were they within a standard of care. Medical attention and physician oversight is part of your practice. In all states, paramedics are practicing under the direction of a physician. So we're an extension of that physician and the physician's license. So that's how medical direction works in Iowa. The Iowa EMS Association was successful probably 15 years ago in enacting legislation, House File 2333. I happened to be president of the association at that time, and we were successful in passing legislation that allowed EMS providers to practice within their scope, to practice a standard of care within their scope of practice wherever healthcare was provided. So that took us out of the back of the ambulance. Prior to that, we could practice medicine under a medical director in the back of an ambulance. But if we staffed an emergency room, we weren't paramedics. We were orderlies or whatever they wanted to call us, and then we often couldn't practice within our scope. We weren't allowed to start IVs or push drugs or those sort of things in a hospital. With this House File 2333, EMS providers of all levels are allowed to practice anywhere healthcare is being offered, as long as it's within their scope. Medical attention, physician oversight. Oh, I already mentioned that, how it's important for medical directors to guide your clinical practice standards. Concurrent medical direction occurs when the paramedic consults with the physician by phone or radio, during the actual call. Maybe a standing order following a set of protocols, that sort of stuff. And retrospective medical direction occurs after the fact and usually is involved in quality assurance programs, case review, run audits, that sort of stuff. Licensure is through the state, so every state has different licensure requirements, although most states are recognizing the National Registry as the organization that that they license you through. So if you pass the National Registry written exam, or I should say when you pass the National Registry written exam and become a paramedic, then the state of Iowa acknowledges that you have demonstrated both didactic and psychomotor skills at the level of a paramedic, and they give you a certification. Liability is a legal responsibility. You are certainly legally responsible for your acts, your omissions, the care that you provide, regardless of whether you're paid or volunteer. You are liable. We do have the Good Samaritan law, but the Good Samaritan law, and I don't think I mentioned it for paid services, if I'm on a paid service and I'm being paid to do this for a living, the Good Samaritan law does not protect me. If I am not on the clock and I certainly pull over at the scene to administer some first aid, I am protected by the Good Samaritan law there. But if you're being compensated, then the Good Samaritan law doesn't protect you. Negligence is failure to act as a reasonably prudent, careful person would, and there are 4 elements of negligence: legal duty, breach of duty, as we had mentioned, and damages, and then causation, with causation being something that's very difficult to prove. Many states recognize immunity through Good Samaritan laws that protect you as long as you're not being compensated and you're acting in good faith. If you're subject to intentional torts, if you assault somebody, if you battery somebody, if you false imprison somebody, you can be found liable for all these all these legal things like defamation of character through libel or slander. Consent is something that certainly you have to get from your patient when necessary. Consent is informed. It can be either expressed or implied by the patient or the person who's legally responsible for the patient, and you need to get it before transporting patients if the injuries are not life-threatening. Refusal of care occurs when a competent patient, after being informed of the risks and consequences of not receiving medical care, decides not to receive medical care. And in those cases, the key there is that they have to be competent, and you have to be able to document that they were competent. HIPAA requires that the health information of an individual is safeguarded, and with HIPAA, just remember need to know. If a person has a need to know the information in the care of the patient, then you feel freely to give them that. But if they don't have a need to know, then don't give it to them. EMTALA is anti-dumping legislation that says that hospitals will provide medical screenings to make sure that an emergency condition doesn't exist before transporting a patient on. And with hospital-based ambulance services, when the patient is on the cot, they're considered to be in the hospital. So many hospital-based ambulance services are required to take the patients back to the hospital before transferring them on. Advanced directives are documents that identify what sort of care should be provided when a person becomes incapacitated and unable to make those decisions, and their condition is terminal. And again, advanced directives often don't apply to EMS providers, only because we cannot make that determination that their condition is terminal and will lead to their death. So that's got to be a physician decision, not our decision. DNR orders are a little different though. In Iowa, we have legislation that protects us in the event that a person has a universal identifier, a medical alert tag that says do not resuscitate, or they have a signed documented, a signed order from themselves, their durable power of attorney, and a physician. You play a vital role in organ donation, particularly in those patients where we discontinue resuscitation and don't transport to the hospital. If you have ever had that opportunity to do that, the Iowa Donor Network is very good about getting back to you, summaries on a quarterly or semi-annual or annual basis of the total number of patients that you've referred, and what sort of donations had occurred, and who got new eyes or new bones or new skin or new valves or those sort of things based on your making that connection between the patient's family and the Iowa Donor Network. Providing care to the patient is your first priority regardless of the scene. Once you've made sure that the scene is safe, then caring for your patient is your highest priority. But understand that, all scenes involving violence could be crime scenes, and that you certainly should do what you can to protect evidence. And then make sure that you document the incident through a run report. And there's we'll have a discussion on therapeutic communication and talk about things like SOAP and chart and methods that providers use to do documentation. And with computer-based medical records and spell check and all those other things, the ability to document more thoroughly becomes easier. All right, well, that brings us to the end of our session, and again I want to thank you, and should you have any questions concerning this medical legal talk, feel free to get a hold of me at that web address, or contact me on the bulletin board on the Iowa Western Paramedic website. Thank you. Talk to you soon.